I was worried when I pulled into the parking lot, I had the wrong Stetson campus, but I looked at the calendar wrong because it's so empty. I thought I'd gone to the wrong one, so. Dorothy D. Fiore here for the Florida Insurance Guarantee Association, which I will call FIGA. They're saving us all a lot of trouble. We're here today because, in all candor, we need some written opinions on this issue. I filed, in this case, I've filed some notices of related cases between me and FIGA's other counsel. We probably have at least 16 or 20 of these cases in which the issue is about enforcing a pre-insolvency settlement agreement. In this case, I think the bigger issue is about the parole evidence rule, because we had a settlement agreement, and in order to interpret it the way the judge did, she had to consider the testimony or the argument of counsel about what was going on in terms of costs and fees, when in fact, it was very clear that they had divided the settlement up and they had paid indemnity and they had paid fee. And so we don't know why the court needed to consider the parole evidence rule when there was no ambiguity in this document or in this agreement. And they went outside to listen to what the attorney had to say at a subsequent rehearing of the case. Now we get into this issue because I think the court's very familiar, and I'm not going to beat the dead horse, that FIGA does not have to pay attorney's fees. FIGA's got covered claims. Very specifically, the legislature limited FIGA's obligations to covered claims.
I want to speculate, but just suppose your predecessor had settled and the parties just said, sent me a $20,000 check, it would be here.
Well, at that point, we would not have a specific statement that this is attorney's fees. I don't know that we would be here, because at that point, one single check, they're not clearly stating this is for attorney's fees.
And the parties to whom the payment would otherwise be made cannot make a request for convenience distribution of the proceeds.
So at that point, you're designating it as an attorney fee. And I think once it's said it's an attorney's fee, then it's very clearly not a covered claim. And therein lies the problem, because FIGA's obligations are limited. And if you look at the history of the tort reform and the changes to the property statutes, it's very clear that the legislature was concerned about the property insurance because the statutory fees were driving up the settlement values so much, so that in some cases where we've had 5,000 go into the insured and 15 and 20 go into the attorney, well, clearly that's a statutory fee.
Okay,
And when,
so if this were a statutory fee, would it be a fee awarded under any other statute than 627 or 28?
not in this case,
Okay, so if you look at Petty made it clear there was a settlement and then there was a fee motion, and the fee was awarded by the court under 627 or 28. That's going to be a judgment decree. Here, you have a settlement. And then it appears that there's a private agreement between the client and the attorney, so they don't both have to go to the bank and endorse the checks. That's common, right?
yes.
And I think your predecessor below said, yeah, it was just the 20,000 would have paid this. But the fact that they separated the fees privately and there's no fee award based on a statute, doesn't that make a difference?
Well, when you have a settlement after suit is filed with an insurance company, they are automatically entitled to the statutory fee at that point. So while you say there has to be a fee award, that is in fact not the
But
case.
did they ask for statutory fee here?
In their complaint, they did, absolutely. Everything in their complaint indicates that they want a fee, that they're going to ask for a statutory fee. And as soon as that insurance company agreed to pay a penny to that insured after suit was filed, they knew they were on the hook for statutory fees.
Yeah, but you don't have to pay a statutory fee without a judgment. There is no judgment.
According to Wallard, you do. Wallard says as soon as you agree to pay.
According to Petty, you do. And that's the Supreme Court.
Well, Wallard was the Supreme Court as well. Wallard is the one who came up with the confession of judgment doctrine that says as soon as you pay after suit is filed, the insurance company owes fees under 627-428. That's why the settlements are so high.
Confession for the underlying carry, correct?
It would be a
There's
question.
no confession of judgment for FIGA.
Exactly.
Unless they deny the claims.
Well, exactly. So United confessed.
So there's really no confession of judgment on FIGA, so that's subject to paying the statutory fee.
Well, FICA should not be subject to.
Well, I agree with you. Tell
Yeah.
policy and
Right.
follow law too, but I'm just trying to get you to focus that how's this not an agreement of convenience when the underlying carrier that you took over, the installment carrier, agreed to pay $20,000. And the last correspondence was for X for indemnity and X for the attorneys, but it was out of the same pot that they agreed, that the insurer agreed to.
And when the insurance company agrees to settle the case, they know they're going to pay fees. So United had agreed that they would include in their settlement the statutory fees that they were going to owe. And that's the problem with what we're doing here, is that United knew it was going to pay, and that's why FICA isn't in the same shoes as United.
But your predecessor below said we need to take evidence, and then the plaintiff below, or the claimant's attorney below, offered to do it and balked. So you waived the evidentiary hearing. So the court accepted the claimant's attorney saying, "Judge, this was just a private agreement of convenience. This wasn't as a result of the award of fees."
And except that the fact that if it's a convenience, this is the fees that I owe, so therefore it's the fees. But again, we get into parole
Is
evidence.
it a statutory fee, or given the math that I saw in the briefs, is purely contingency fee?
Well, so there was nothing that specified that. And if the court believes that's the distinguishing factor, I think providing guidance to the trial courts would be very helpful. But we come into the problem where in this case, it looks like we have a fairly mathematical calculation and then some representation that there were some additional costs that would bump it up over that mathematical calculation. But what about the cases where the fees are far in excess of any percentage of the recovery? In that case, it's very clear. So if this needs to be a case-by-case analysis.
In that situation, I think you have a stronger case, it's a statutory fee.
Agreed. So if that's what the courts need to do, let's make it clear to that we have to look at the facts of each case. I've had cases with the AOB providers where they have a very specific invoice, and then the settlement was in excess of the invoice. Well, I think that's very, very clear, correct? But where do we draw the line, and what is the guidance that the court needs? And that's what I'm asking you to do, is give us some guidance as how to determine whether or not these are settlement agreements for convenience or these settlement agreements that just don't necessarily want to break out in the number. But when you're asking us to pay a fee that you've clearly said is the fee that is owed under a statute, because as soon as United agreed to settle, United had to pay statutory fees. FICA does not have to pay United's obligation for statutory fees. In Petty and in Soto and in just Petty and Soto, they both had triggered the obligation to pay statutory fees. And the Supreme Court said and they both had agreed that had they stayed solvent, they would have paid statutory fees. And the Petty Court said it doesn't matter if they're statutory fees, FICA does not have to pick up the insolvent carrier's fee obligation. So when the insolvent carrier agreed to settle, the insolvent agreement triggered their obligation to pay that statutory fee. Because as soon as you agree to settle, as soon as you pay the money, you're on the hook. And that's what the Supreme Court and the legislature didn't want for FICA, because FICA frequently has to, in fact, FICA almost always has to pay after suit's been filed, and they didn't want that. So if FICA doesn't trigger their own obligation, they shouldn't have to pick up the insolvent carrier's obligation to pay fees either. So
the equities are, maybe it's a matter more for the legislature. Law firms denied their fee for whatever amount of work they put into the case.
Well, that happens. The legislature did make that decision in a lot of cases. And that's what they said. If FICA took over the case and paid the invoice, then the attorney doesn't get a fee because FICA doesn't owe a statutory fee, right? In the sinkhole case, the attorney can't even take a percentage recovery. So the legislature is free to limit FICA's obligations, and they did. They said very clearly, FICA shouldn't have to pay the statutory fees that were otherwise owed by the insolvent carrier. It's only if FICA owes them because of FICA's conduct. And I think when you look at these cases, and again, if you say this case should be affirmed and the judge was right, and I have the utmost respect for our trial judges struggling with this issue, I hesitate to even say they err because there's just such a complete vacuum of information for us to rely on. let's explain to the trial courts what they need to look for and what is the facts that would show that this was clearly a statutory fee versus this is a fee of convenience. It's just a split of the insured's indemnity payment. Because I think what we run into over and over again is a global number that gets divided up and you don't know. And do they need to take actual evidence that's competent, substantial evidence, sworn testimony, et cetera, in order to establish?
What is key to your argument? Is it because they asked for statutory fees in the complaint?
Yes. And they asked for them in the complaint. The settlement agreement shows they resolved that claim. And that, again, there's no question that once United agreed to pay, they were going to owe. And so the combination of those three things shows that there is a fee component to this settlement.
So if I ask for fees, but I don't specify statutory fees, and then there's a settlement, and then there's a request of convenience to divvy up the proceeds, FICA doesn't have a problem with paying.
Well, at that point, if you haven't asked for statutory fees and there isn't going to be entitlement to a fee, then I don't think that that would be a problem, right? So if we have an insolvency now where there is no 627,428, well, then I think at that point, it's not statutory fees and 63170 wouldn't have been involved. Of course, we don't have 63170 anymore either, so. Yeah. So it's come up a lot and it really is a situation. I don't really think I need to beat the horse. The facts are really not in question. The law about FICA is not in question. What the court looked at in order to make the decision on rehearing it's all very clear. I just think that we need to have some clarification so that going forward, we still have a lot of these because UPCIC had 50,000 cases when they went insolvent. I'm not gonna say they were all in settlement stage, but there's a lot of cases out there in which this has happened. And that's really the reason why we started to ask for oral argument is so we could try to get here and get some guidance from the court on how does a judge, how does the counsel make a decision in terms of what's the covered claim and what's not. FICA wants to pay what they owe. I will say that FICA always does. And if in fact, this is not something the legislature has said FICA can't pay, FICA will pay it. But we have a mandate from the legislature that says, save the funds in the insolvent estate, and we're not paying the insolvent carrier's insurance obligation or fee obligations. You're only going to pay the insurance obligation, the indemnity. And so if the legislature has said we can't pay those part of the claim that's not the indemnity, how does FICA know? How does FICA know if they're fulfilling their legislative mandate or they're frittering away the funds that they're fiduciary to protect? And we need the guidance. So that's pretty much where I'm here. I think when I hear the questions from the court, I don't really think if you have more questions, I'm happy to answer, but I don't think me standing up here beating a dead horse is accomplishing much. I'll pass it to my opposing counsel. So.
Thank you. Is it Mr. Watson?
Owner Consultant, Your Honor.
Oh, okay, I'm sorry.
I filed a notice of appearance last week. May it please the court. So, Your Honors, this is really a simple issue. It's basically, does the settlement instructions change the underlying settlement? I mean, it boiled down to its most simple form. That's why we're here. United, their communication was that they were offering a $20,000 lump sum payment. There was no talk of attorney fees. There was no stipulation for attorney fees, or statutory attorney fees. There was no motion for fees filed. It was basically a $20,000 lump sum. And again, as Your Honors pointed out, the payment instructions were done for convenience. We had a contract with our client for 33 1/3% plus costs in the event of the indemnity recovery. That's what happened. We recovered $20,000. Therefore, pursuant to our agreement, we were owed 33 1/3% of that amount plus costs. Petty and Soto, it deals with a completely different situation. You're dealing with exactly what I just mentioned did not happen in this case, where you're dealing with a indemnity settlement and then either a stipulation for fee entitlement or a motion for a fee entitlement. So, earlier my opposing counsel mentioned, if there's not an entitlement to a fee, then they don't have a problem paying. Well, that's exactly the situation here. There isn't a fee entitlement. We're being paid our fee pursuant to a contract. And
But your complaint requested statutory fees.
correct. And in the event that we had secured a judgment, then we would have, possibly sought fees under that. But that's not what happened. We settled. And the settlement, it was for a $20,000 lump sum payment. So it's our position that's an
So
indemnity
if
payment.
you had reached in, if you get to a judgment, made statutory claim, and your proposed number is the same as your contingency recovery, like you would not have paid.
Well, I don't believe our number would have been the same had that happened because the way of calculating that would have been different because under a statutory fee, we would be, it's very similar to a, sorry, the word escapes me.
When you have a fee,
Quantum merit. It would have been similar to a
would
quantum.
it be a fee hearing factors too?
Correct,
And
exactly.
the fee hearing is for an additional amount beyond your 33%, your contingency.
Well, no, our contingency, basically, if there's a statutory fee award, I
Right.
mean, that's what we'd be entitled to. But that's not what happened.
627, 428 was basically a prevailing party field,
Correct.
central field. But so you would be awarded fees per prevail. You still get your 33%. So, but a court award would be an additional amount, correct?
It would be correct.
Okay.
Yes. But as I said, it was a settlement. So, it wasn't.
Yeah, I guess it's unclear here. I mean, because you see we see that email February 21st, 2023. My client sets the offer $20,000, and then you break down the payments. I don't see anything from the carrier, acknowledging. I'm not sitting here saying you don't have a settlement, and they didn't agree to that. I think what Fiverr's problem below was there wasn't any evidence that the carrier, for whom they assumed, the defense, agreed to that breakdown, and it was your contractual fee award versus something they were compelled to pay by statute.
Mhm.
Does that make sense?
It does, Your Honor, and I think the difference here, it's not so much the breakdown, it's the settlement that the adjuster offered. It was a $20,000 lump sum settlement. So as a convenience factor, we asked that they split the check. And again, the check, the way we calculate the check is 33 and 30% of that indemnity payment that we received, plus costs. Had that $20,000 simply been indemnity and we stipulated that we were still, that we were going to be entitled to our fees through the statutory fee mechanism, that amount would have been different. There would have been a completely different way of calculating it, and it would have required it would have required either FICA to agree to it or to a court to order it.
And even if they ordered it, they're not, Fiverr's not required to pay.
Correct, right.
Okay.
But, and again, at the time of that agreement, FICA wasn't in the picture. It was between us and the agreement was between the appellees and the prior insurer. And the prior insurer made an offer for a $20,000 lump sum settlement, and we accepted. And, basically the way we asked for the, checks to be made out is exactly how we would have made it out from our trust account. And it was just to save an, extra step. And I think we have to really focus on, the principle that, the payment instructions, they don't alter the original settlement. The original settlement was a $20,000 lump sum payment. And, it's our position that's an indemnity payment. The instructions don't go back and alter what it was at that point. If we had settled attorney fees, we would have used the language attorney fees. We would have said it's a $20,000 indemnity payment. We're stipulating that we're entitled to attorney fees, or we would have filed a motion with the court for attorney fees. None of those things happened. That's what sets this case apart from Penny and Soto.
Anything else, counsel?
No, Your Honor.
Very good. Thank you. What do you have?
I know, again, I'm not a fan of,
Can I ask you a question? Suppose they had requested, $20,000, and let's split the check, 3 checks. One for the homeowners, one for the law firm, and one for it's 3 names, 3, I'm sorry.
Okay.
Law firm, the client, and the mortgagee. How's that?
and again, the amount that would be paid to the attorney would be statutory fees. I think that it's very clear that when insurance companies had to settle these cases before they repealed 627428, that all the settlements were aggravated, they were increased because they recognized the fee obligation. So it was not like this case was worth 20,000. They knew that they had to pay the attorney out of the value of out of the settlement because they had a fee obligation. So the settlements were much higher than they would otherwise have needed to be if they were just settling indemnity. They demanded attorney's fees. The whole purpose of a global, when we call it a global, is that it's going to cover all the elements. Some of these cases even have claims for bad faith in them. So it's covering all the things that they were asking for, the fees, the cost, the interest, all of those things were factored in to drive up the value of this case. Apparently, Mr. and Mrs. Hernandez could have only really needed about, $10,000. And yet we had to pay $20,000 to settle the case. And that's what FIGA is concerned about, is that these inflated settlements, and again, not that I'm not suggesting anyone in this case is doing anything improper, but the value of the settlement has to go higher because the insurance company had to pay the fees. And so FIGA comes in and they should not have to pay that that inflationary component.
Predecessor below conceded that if the settlement's 20,000, regardless of what their private communications were for a fee breakdown, they pay it. Here, you just simply have it on paper that these are our contractual fees. I understand and I appreciate that you want us to write, but it seems to me that whichever way you go, if writing an affirming opinion, it sounds like FIGA would have to agree that this indeed was a settlement and this was a private agreement of convenience to break it down. And we make that distinction. Or if we go your way to reverse, we have to define that it is a statutory attorney fee award where, quite honestly, the record doesn't bear that out because there's no decree or judgment from a court awarding the fees, despite the fact that they had the prayer for. You understand what I'm saying?
I do understand. I just think that the focus on the fact that they have to get a fee award is misplaced because in fact, the fee award itself, the entitlement determination is only a pro forma process and once the insurance company has paid after suit is filed. We frequently stipulate to entitlement. In fact, when I can quote confess judgment, I put that in there to avoid being charged for the motion to determine entitlement. So as soon as they say that, it's a pro forma on entitlement to the fee. And then the only issue is the amount, which by the way, I don't believe the attorneys get their percentage recovery plus the statutory fee. I think their contracts usually say either or, whichever's higher. But
Let me ask one question because I forgot. I think there was a point in time where the claimant's attorney said, forget 2 checks, I'll just take 1. Was that true? That didn't occur?
I saw that in the record as terms of statements. Yeah,
Was that a last ask?
I think so.
Okay.
I think so.
Okay.
All right. And I think that's all. Thank you very much. We appreciate your time all by ourselves.
Thank you both. With that, our docket, if you don't, and we are